Well, good afternoon. Thank you for joining us today as we dive in a little bit deeper to some topics relating to Recordkeeper benchmarking. But as you can see from the title on the screen, the emphasis here is not really that everything should be fees, 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 not that everything should be fee driven. Frankly, the benchmarking exercise is about a lot more than merely fees. And we're going to get to the bottom of that a little bit today and give you some tips and some ideas for you to use as you work with your advisor, your consultant about how and why you might go through a benchmarking exercise. I mean, the reality of this, and if you joined us last month, we talked about the increase in litigation, and we continue to see more and more lawsuits filed across the country. Post-COVID, the explosion of lawsuits has been pretty astonishing, and the reality of this is that the risk of lawsuits is no longer limited only to specific companies, and in particular, no longer limited only to private companies. Now, in addition to that, it's also not limited only to mega plans. What we're seeing is the plaintiffs' firms are able to come down market. They're able to get better data. They have more money in their coffers from the success that they've had in the mega plan market, which makes it easier for them to speculate on litigation involving smaller plans. And really, it's the bar chart at the right here that fuels that capability. It's the idea that there are more and more settlements, and because there are more and more settlements, there is more money again in the coffers, which allows them to get going and rolling downhill with more and more litigation. And this is really the key slide that relates to what we wrote about in this month's newsletter. And so here's the background around this. You may remember that the Hughes versus Northwestern University case was, on the one hand, about share classes. It was really examining whether it was appropriate for that plan or those plans at Northwestern University to use anything other than the cheapest version of the investment options made available within the plan. And so the Supreme Court dove into that a little bit and said, hey, fiduciaries, you have an ongoing fiduciary responsibility with respect to each and every investment option within the plan. So of course it's not okay to say you can have bad investment options simply because you have good investment options, or you can have expensive options just because you have some cheap ones. But the other key part to that Hughes versus Northwestern opinion at the Supreme Court level is that it dealt with what the plaintiffs must plead in order to survive a motion to dismiss. And if any of you have been involved in litigation, you know that one of the worst parts about litigation, it's not the courtroom at the end of the process. Statistically, fewer and fewer lawsuits make it all the way to that point. What's the real pain? It's the discovery phase, isn't it? It's that notion that you have to appear for or participate in some sort of deposition, or that you have to respond to interrogatories, or you have to respond to requests for production. You have to dig through your emails and dig through your files and dig through your mail and find all that information. So when the Supreme Court says, hey, lower courts, you need to apply this particular standard when the participants file a lawsuit, when that standard is being applied, we're seeing that more and more cases are getting through that motion to dismiss. So what does that mean? It means that more and more cases are getting to the point where companies like yours are saying, well, we don't want to get involved in discovery, so let's find a way to settle the lawsuit. And so that's really the big question. The big question is, can the participants or the plaintiffs get by that motion to dismiss phase? What does that really mean if we put aside the legalese? It means that the company, the fiduciaries, get sued, and they say to the court, throw this case out, dismiss this case, it shouldn't go forward, there's not enough pled here. And the participants, the plaintiffs, are saying, we've shown enough, there's enough detail. But if you might remember from last time we talked in September, the results are all over the place. So I'm showing you charts that were included in two very large lawsuits. Look at the one on the left. Within this plan, the average cost per participant for the record-keeping expenses was $64 per participant. And you look up and down that list, you can see that similarly sized plans range from $28 to $42. So in that plan, those people were paying 2x to 3x what the market rate was. And then look over to the right, and you can see another plan about $1.4 billion where the plaintiffs' firms went through this effort and found that they were paying $72 in that plan, whereas the reasonable range within the marketplace was something in the neighborhood of $28 to $36 or so. So again, paying 2x to 3x what the going market rate is. So you see those, and if all you're thinking about is risk, you'd be encouraged by the fact that both of the courts threw these cases out, dismissed these cases, and said, you know what, you haven't really pled well enough, participants, to demonstrate that all of these record-keeping expenses should be the same because all the services are the same. In essence, the courts have said record-keeping services aren't necessarily a commodity. And so when the participants file these lawsuits, they can't just say, in the case of the plan on the left, hey, $64, that's too expensive, there should be liability. They have to say, hey, $64 is too expensive, and it's too expensive because the services are the same there as they are in the other plans. And so as you think about that, as I mentioned, you might be encouraged. From a pure risk management fiduciary perspective, you might say, hey, that's a great outcome for my company. And look on the right, and you might feel the same way. So from a risk management perspective, whether that's your direct role at the company or you have an indirect role where other leaders in the organization are depending on you for that aspect, you can share this information with them and say, hey, right now, because there's this pleading issue, we can see some very large plans that are getting by with overcharging their people. But think about what I just said there. Is that really the message that you want to share within your organization? Hey, good news. We can get by with overcharging our people as long as the plaintiffs aren't very good at how they file their pleadings. And as you can see at the question at the top, do your employees care only about procedure? And do you care only about procedure for your employees? Do you care only about being able to say, like, hey, as a matter of civil procedure here, like, these cases will be thrown out so there won't be any liability? I would guess that for most of you, the answer is no. Most of you are saying, okay, that's great. Matthew, you've told us that we can control our risk. There may not be that much risk for this. But then we say, are there various reasons, though, to still go through a benchmarking process? Let's think about the Cook plan on the left or the Denso plan on the right. Aren't there some pretty good arguments that they should have worked through a benchmarking exercise? You better believe they're doing it now, right? But wouldn't you rather get out and do it ahead of time so that you're not doing it on your heels in response to litigation, but you're doing it in advance of litigation? So as we think about benchmarking, and before I get into some tips on how to work through that, I want to highlight for you that we think there are 4 key reasons for you to go through that benchmarking or that due diligence exercise with respect to your record-keeping expenses. The first of those is the 408b2 regulations, the notion that if you're paying more than reasonable compensation, then there's a prohibited transaction. So, okay, for the people who are involved with or concerned with risk in your organization, federal regulations right there, that's a great reason to do the benchmarking. Number 2, similarly, the federal courts look at this and say, boy, there's an allegation that the expenses were unreasonable. How can we tell if they're unreasonable if you're not looking at the marketplace? So there's an expectation that there be some sort of frequent benchmarking, and some of the courts have said, hey, as frequently as every 3 years. You can find other courts who say, hey, it doesn't have to be every 3 years, but it needs to happen, and needs to happen somewhat regularly. So those are really kind of the risk-related reasons. But as I mentioned earlier, it's about far more than just fees, isn't it? Let's talk about items 3 and 4 here. Why else might you say to your advisor, hey, we should take a look at our record-keeping expenses? Well, number 3 is the changes in the market have been so rapid, and we've seen fee compression plus all this technological innovation, and these record keepers are figuring out more and more about what the current day employees need and want from their 401k, their 403b, their pension plans. And so what's happened is you truly can get more for less within that marketplace. If you have not looked at your record keeping expenses for a few years, I would expect that you will see not only a fee reduction as a part of that process, but you also will see that there are additional bells and whistles, if you will. There are additional services available to your people that your current relationship manager has said, I don't really want to get into that because I don't want to rock the boat. But when that organization finds out that it's potentially at risk, or at least it's under a microscope, it's much more likely to say, hey, not only are our fees already reasonable, or not only might our fees be lower as a result of this process, but look at all the new things we have to share with your people. And finally, that's not item 4, just doing right by your people. As I mentioned earlier, do we really feel good about looking at a large lawsuit and say, hey, good news, there's no liability for that company that caused its people to pay 2 to 3 times the market rate because the plaintiffs didn't handle the pleading appropriately? I don't think that's the result any of us are aiming for. And so more than anything, we want to be guided by trying to do right for your people. So here are our tips. And as you work with your advisor or your consultant, you'll find additional kind of personal preferences that they have for accomplishing what we're trying to accomplish with these tips. But number 1, don't pull it off the shelf. See RFPs all the time that have been put out there by a couple of organizations that are out on the internet. And the moment I see that, the moment I read through and see that there's a couple of distinctively asked questions, I say, oh my gosh, this thing has been prepared without any sort of personalization or customization for this specific plan or this specific organization. And so tip number 2 is go through an internal interview process to start. And I think your QPA advisors will do this with you. They'll say, hey, before we put out this RFP of sorts, or before we put out this benchmarking or this request for pricing, we want to ask the people who touch the plan on a day-to-day basis, where's your heartache? Where do you get heartburn? What's working well? If you could fix one thing, what would it be? What are the non-negotiables? What are the things that we absolutely must have if we make a change? And then also ask the fiduciaries, ask the committee members, hey, we're going to go through this exercise. What would your priorities be? And then item number 3, just keep in mind, it doesn't have to be a full-blown RFP. I mean, you can call it an RFP, and that's fine. It's absolutely okay, but it doesn't have to be something with 100 questions in it. I would argue that once you get beyond about 40 questions, maybe it's 45, somewhere in there, with each additional question, that exercise should have less and less credibility in your eyes. Because there are so many of those prerequisite questions, that data should already be gathered, and you should already know, how long that organization has been in the business, and roughly how many plans do they have, and roughly how many of those are defined contribution plans. But what that RFP ought to do, or that request for information, or that benchmarking exercise, is it really ought to speak to the things mostly important for you. And then finally, this is my preference and it's not everybody's, but if you'll entertain the idea, you can see where there might be value. When you get the report back from your advisor, or as you talk about with the committee, the initial proposals, separate the pricing from that conversation. The first thing you want to do is look at a bunch of options and say, which one do we like the most? Which one do we like the second most? Which one do we know is not an option for us? Start there. Then once you start to identify the actual candidates to provide those services for you, then we start talking about pricing. But if you put that in too early, we'll have individuals who walk through and carve out potentially great solutions simply because they're expensive, or they'll hone in on or zero in on and prefer something simply because it's the cheapest. It ought to be about value. Start there, formulate your list of preferences, and then follow up by including the pricing in this. Maybe it's a tiebreaker, maybe it's an influencer. It's certainly a relevant fact, but it shouldn't drive that entire process. I wanted to show you as we wrap up here today, this is what we use for the cover of our report. And you'll notice what we're talking about here. It's benchmarking, it's a due diligence report. We're trying to make sure we're benchmarking the fees, but also the services. And that's the due diligence that we want to perform and that you should be out there performing. Go through that process, utilizing those tips that I shared. Ask those questions of your people in advance, and then really do it for the right reasons. Don't do it because you're going to get sued. Don't do it because other companies are getting sued, or don't refuse to do it simply because you know that some of these large companies are escaping liability. Let's do it because the regulations say to do it, the courts say to do it. So much has changed in the industry. And finally, let's do it so we can tell your people, hey, we've done right by you. We've done the best we can. So thanks again for joining us. I hope you'll find time to register for these upcoming events we have. We have a Fit for Learning Financial Wellness webinar coming up on October 25th. We'll have our ERISA attorney team, Chuck Smith and Scott Liggett, Mike Smoots, and I will be together to talk at length, probably with an update on Secure 2.0. I just came off a Secure 2.0 webinar with the government today, and they told us in typical government speak that the Secure 2.0 grab bag timing is likely to be, and I quote, faster than fairly soon and maybe almost imminent, end quote. So if you can decipher what that means and let me know, I'd sure appreciate it, but it looks like we will receive some guidance very soon. So again, thank you everybody for joining us. If you have any questions, if we can help you with anything at any time, please don't hesitate to reach out to anybody at QPA, and certainly feel comfortable talking to your advisor about any of these topics. Have a great rest of your day. Thanks so much.